Valley Ltd and others, and Lupton Fawcett LLP.
Mr. Pickering.
My Lord, perhaps I can start with the introductions.
Yep.
Lord, I, together with my own friend Mr. Doherty, appear on behalf of the claimant appellants. My own friend Ms. Manby appears for the second defendant respondent, Lupton Fawcett.
Thank you.
And as your Lordship will be aware, this is the claimant's application for permission to appeal, this hearing having been directed by Lord Justice Bean, pursuant to CPR 52.55.
Yeah.
My Lord, in terms of papers, in addition to the core and supplementary bundles, can I check that your Lordship has received our supplemental skeleton argument and our small bundle of authorities?
Yes, I did. Thank you.
I'm grateful.
And just in terms, I see this is listed by Lord Justice Bean for an hour. Have you worked out a division of sort of hearing time between you?
My Lord, no.
Right. Do you want me to impose one, or do you want to suggest one?
My Lord, I suspect I would invite the court to allow me 40 minutes or so.
35 minutes, 20 minutes, 5-minute reply.
My Lord, yes.
Okay, let's get on with it.
My Lord, yes. As your Lordship may have picked up from our supplemental skeleton, we have 3 headline points. If I can just outline what they are. First, because of what we describe as the immediately, necessarily and automatically incurred expenditure.
Yep.
In other words, expenditures, commissions and professional fees which only were incurred in the event of the investment taking place. We say because of that, the receipt of investment monies was not balance sheet neutral, such that unlike the Stanford case,
Yeah, I've got that point. Where in your particulars of claim, amended particulars of claim, is these monies pleaded?
My Lord, it's not broken down.
Right.
We simply claimed.
No, I appreciate that, and we're at the stage of, have you got a real prospect of success, of showing that there's a realistic prospect of success on the claim? That's the test that I will be applying, unless their submissions to the contrary. But just trying to work out, looking at your particulars of claim, I couldn't see this particular way of putting it there. I have well in mind the respondent claims that you keep on changing your case. So I was just trying to chase it down in the particulars of claim. Is it there?
My Lord, it's not broken down because there's been no, we simply pleaded a figure of loss. And of course, there's been no defence, nothing's been put in issue in terms of statements of case.
I understand that, but the loss could be the fact we had commissions up to about 50% of the money that came in. Is that a head of loss that's pleaded?
My Lord, everything is claimed. So
Yeah,
Lord,
no. Well, can you just show me where it is then?
Lord, I can show you the general claim for loss within the particulars of amended particulars of claim. That appears in the supplemental bundle.
Yeah.
My Lord.
In this, well, no, I've got them in the core bundle.
Ah. My Lord, yes, it's actually in both. My Lord, I can tell your Lordship that particulars of loss, it's simply we claim the full amount of all the investment monies. We haven't broken it down because the way this has come about is that the defendants have raised a point, not in a pleading, but simply within an application, saying that no loss has in fact been suffered.
Well, that they provisionally, just so that you fairly know, are right if they're talking about Stanford International, and just so that Miss fairly knows, I can well see your point in relation to funds that you have to get by way of commission. But when I tried to check to see whether this was a pleaded claim, I couldn't find it. That's why the whole point of an oral hearing is to give you the chance to answer my concern.
Well, yes, it's not particularised. We simply plead all.
Yeah, well, I appreciate that, which is why you got the all response, which was money in, money out, and no loss. As I understand the genesis of these points, and it's no criticism, because obviously as the arguments become more sophisticated, the responses become more sophisticated. you're now saying, well, actually, if you put it this way, we can actually identify a recoverable head of loss.
My lord, yes, and in fact,
But it's just not at the moment part of the pleading.
my lord, we accept that.
Yeah.
So there are three headline points. The first is that the Commission's liabilities, which were only created on the transaction. Well, the second headline point is the statutory compensation provision. That's an additional reason why the receipt of investment monies was not balance sheet neutral.
That is your third ground of appeal, is it?
My lord, yes.
Yeah. I should just, because, as a matter of fairness, because I'm going to call it out when I give a judgment on this, point out that grounds of appeal are not meant to include argument, and you go to 8 pages and include argument.
Okay.
Do you want to say anything about that?
I apologise for taking up the court's time.
No, don't worry, it's all fine. But you know, we are meant to try and ensure that grounds of appeal are grounds of appeal, not argument.
My lord, yes, and I apologise.
So this is your third ground of appeal, that the statutory compensation.
My lord, yes.
Yeah.
And in a nutshell, your lordship will see that the regime is that if it's an unauthorised investment scheme, on that basis, the investor, he or she, is entitled to return of their money and compensation. It's absolutely right. They can't have their cake and eat it. They can't.
Yeah.
They have to return any benefits received.
They can't claim the 16% you were promising.
Well, they can't claim that contractually. But
No.
as well as the money back, they can claim compensation and the question what that is. And so
As I understand it, the judge below said, yeah, fine in theory, but no one's done it yet, and therefore this is theoretical. What do you say to that?
my lord, the judge did say that, but with respect, that's not actually the correct position factually. Proofs have been invited, they have been received. In the usual way, the liquidators have not yet adjudicated upon the proofs until there are funds in place. But the various proofs, and there are many, include claims for compensation, which haven't yet been adjudicated upon.
And where do I get that from the evidence to show that the judge was wrong?
My lord, I'm not sure that's in the evidence because it wasn't something which was suggested. It wasn't suggested in evidence that there hadn't been a claim. It was something which came up in oral argument.
It came up in oral argument. The judge gave a judgment on it. You say the judge is wrong. You would expect, therefore, to see a application for permission to rely on a very short witness statement saying, here are 5 proofs in which these claims have been made. Anyway, you're telling me there are those proofs.
My lord, the judge asked for instructions what compensation claims, and I wasn't able to answer. I didn't have that information.
Yeah.
But the judge, I think the judge said in the judgment that he wasn't aware of any compensation claims. The position, in fact, is that there are claims for compensation which have not yet been adjudicated upon in the usual way that liquidations work.
Well, I understand that, but one might have thought that, given that he'd said that this would have been put. I mean, it's not in your skeleton argument that there are such claims, is it?
Well, look, we don't expressly say that, but we do refer to claims for compensation.
Well, I appreciate that, but you know that the judge. I mean, as I said, the judge said, well, this is all theoretical. Now, I understand your point on EasyJet on that, but I mean, he did say it was all theoretical. Anyway, okay, you're saying that there are in fact proofs.
My lord, yes, we haven't had evidence yet, indeed. And if your lordship, if the court were minded to grant permission, with permission, we would seek to put in. I can take an undertaking now to file evidence confirming what I've just informed the court, that there are in fact claims for compensation. I can.
Well, as long as it's a 2-page witness statement rather than a 15-page witness statement with costing a great fortune.
My lord, yes.
We are there.
My lord, yes. But the short point is, and your lord, and I'll be expanding upon this, but I'm just headlining it now, is that if one has a hypothetical investment of £100,000, that investor is entitled to not only the £100,000 back, but compensation. Now, that compensation question, it could be interest, it could be what he or she would have done with the money.
I'd have invested in a real scheme that might have meant that I got a real return rather than a Ponzi scheme. Yeah.
Well,
credit-
Lord, yes, but the
the
point,
yeah.
but the point is, it's not balance sheet neutral. If these had not been CIS, the entitlement of the investor, he or she, would simply be entitled to the value of their investment, whatever it was worth. It might be up or down, but it would have been whatever it was. Because these were unauthorised CIS, immediately the company became liable not only to the money which it had received, but also for some form of compensation, to be determined, but some form of compensation. So again,
And
it's
would
not
that
balance
be
sheet neutral.
limited by the sort of Hadley and Baxendale, or would it be a different head of type of loss contemplation?
My lord, in terms of the compensation, the heads, there is no clear authority as far as I'm aware. But one would imagine it would be interest or what he or she would have done with the money, and each adjudication might or would have a different result, no doubt. Or
So,
would have some principles.
and again, without being really boring about these things, but it was a strikeout of your pleading. Where is this pleaded?
Lord, that again, it's not specifically pleaded. We simply pleaded the full amount, and these are points which have been raised in argument that our claim cannot. It's been said that the claimants cannot have suffered loss as a theoretical argument.
Well,
So it
to the
wasn't-
extent that you pleaded money in, money out, as I've said provisionally, I entirely agree. That's what Stanford Investment International Bank says. But to the extent that you break it down and put different heads, that might be different. So, I mean, it may well be the judge was entirely right to strike out the pleading as it stands.
My Lord, I mean, one, and I'd be reminded by my junior, we do have a claim for an indemnity on very much on the basis
Right,
of
well, I did ask, where is it then?
my Lord, the indemnity appears towards the end of the pleading.
I mean, again, it's entirely up to you how you plead your case, but to get up to 250 odd paragraphs doesn't really help anyone.
Lord. Perhaps I can ask. Mr. Dockett is going to find the indemnity provision, but your lordship will.
Because all I've got at the moment is paragraph 251, as against LF, not less than 63 million and then 12 million.
My lord, yes. I mean, what's the way the case has.
But I mean, when you pleaded 250 paragraphs, if you can't even particularise how you put your loss so that it is justiciable, it's not surprising that you end up with an application to strike out.
Lord, yes, I followed that point. If there had been a defence which had taken issue with the quantum, this might have resulted in a more particularised fix of claim, or indeed a reply which dealt with these points. But Lord, at this stage we've simply pleaded the full amount of loss, and we've responded to the suggestion that no loss is capable of rising as a matter of law, which we say is wrong. And those are the first two reasons. First, the commission type expenditure, and secondly, the compensation.
Yeah.
But, my lord, we accept entirely that, save for the reference to indemnity, there is no specific breakdown of those, figures.
If Mr. O'Doherty is very helpfully helping, perhaps he can just check to see whether there's any reference to the commissions at all in the pleadings.
Well, I think the answer is no, but no doubt.
Yeah, well, I couldn't see it, but on the other hand, you've had the papers for a lot longer than I have.
Well, yes.
Yeah, thank you.
And the third headline point is in relation to the balance of the investment monies, which we basically say this case is a million miles away from that of Saddington, on which the judge below relied. My Lord, I was going to take your lordship through some of the background, but my lord, it's at pages 57. Small. It's at page paragraph 66 of the amended particulars of claim.
Thank you.
Your lordship will see that in 65, we refer to each of the asset SPVs becoming insolvent, despite raising £68 million. In 66, we seek declarations of schemes of CISs operated in breach of the FISMA provisions. They're liable to the creditors by operation of Section 26. And as the final sentence, indemnities from the defendants for such losses that arise by operation of Section 66. And if one goes to the prayer, subparagraph 4.
Yep.
One can see the position there too, and all necessary accounts and inquiries.
May I say, just putting all necessary accounts and inquiries is hardly an adequate pleading.
I note your Lordship's point, and perhaps I could invite the court to go back to paragraph 40. 42 and 43.
Yep.
We refer in 42.4 to the sales commissions of up to 12.5%. And in 43, Your Lordship will see the references there to the commissions.
So how does that work? The sales agents get 12.5%.
Lord, yes.
And then what does the developer's deferred investment mean?
Monies from the initial monies received from the investors, money goes back to the developers who are entitled to money if the investment is made.
And who are the developers?
Developers would vary from scheme to scheme.
And 40% went back to them.
Well, yes.
And 12.5% for those. And the reason I ask, because this was, it's now common ground, a Ponzi scheme, and writing something as deferred investment interest, it has all the hallmarks of the beginning of a fraud. So just tell me who the developers were. Were they part and parcel of the fraud? Because that's relevant to the scope of duty. That's the reason I'm asking these questions.
Well, Lord, yes. It's one of the SPVs, wasn't it?
SPV plus NPD. Yeah, one by the same individual.
My Lord, yes. Other group companies.
Yes. So basically, you put in £100 and 40% goes straight back to another group company under an alleged contractual obligation.
Lord, yes.
Yes, thank you.
But in terms of the sales commissions, these were independent third-party agents. And in terms of the professional and the legal fees, these were independent firms. So that's why in our supplemental skeleton argument, we've referred to those three matters being the immediately automatically necessarily incurred. So for £100 or £100,000, straight away, a sales agent would get up to 12.5%. And that's an independent fee, not part of the scheme. And indeed, professional fees on both sides would come out of it. So that goes to the first point. So that's unlike.
Do you plead the professional fees, by the way?
And my Lord, yes, that's referred to.
Is that in 44?
Lord, I think so, yes.
It's page 103, and after payment of legal and other costs.
My Lord, yes. So, Lord, in terms of those, perhaps I can just go through in the time I have to these three headline points in slightly more detail. In terms of what I've described as the immediately incurred expenditure, Lordship, we discussed that to some length, and we accept entirely the reasoning in Stanford. We've never questioned that. We've never suggested that Stanford is wrong, but Stanford applies in relation to a pre-existing liability. And the point made by the Chancellor, as he then was that the net balance sheet position didn't change. Monies went out of one account, but they paid off a liability of another account. And so to that extent, and we've never questioned Stanford as being anything other than good law. But we say that in terms of the expenditure which goes to these independent third parties, which was only incurred as a result of the transaction, that is fundamentally different. So £100,000 comes in, and one can think of it as how it works in practice. So, my lord, an investor transfers £100,000 in escrow to the SPV solicitor. The investment hasn't yet been made. No legal costs. There's no entitlement to the commission at this stage. And then, on the green light being given, monies go to the SPV, but it's not the full £100,000 because it's net of all the expenditure which has been incurred as a direct result and only because of the transaction. And those are chunky sales commissions. They're 12.5% plus the legal fees. My lord, the other way it could have been done in practice is that the £100,000 is paid directly to the SPV, but on receipt, the SPV immediately becomes liable to pay, for example, 12.5% commission. So it's not balance sheet neutral. So this is fundamentally different from SIB, where monies were simply transferred from one place to another with no net change in the balance sheet, where here, the very making of the transaction created liabilities. Now, my lord, we accept that this isn't pleaded as fully as it could be, but your lordship, we invite the court to appreciate how this has come about, in that these points were taken simply in the strikeout and summary judgment application as a matter of principle that no loss could have been suffered. And we say that's wrong. And in terms of that, we invite the court to look at what the judge said in relation to this particular point. My lord, it's in core bundle page 73.
Paragraph 101, yeah.
Paragraph 110, my lord.
110, right, yeah.
It says that I, for the claimants, accepted that this would be the case if the investment monies were simply held by the claimants, or if they were used to discharge existing liabilities, but argued that this did not apply when the monies are paid to discharge future or ongoing liabilities, especially when those liabilities are the inevitable consequence of the receipt of the investment or form part of the transaction cost for those investments, such as sales agents' commissions or solicitors' fees. And the judge then said this: it seems to me, however, that there is no difference between the two situations. Both involve the payment to discharge liabilities in respect of which the claimants have received consideration. And my lord, in respect of that final sentence, it's true in itself. It's absolutely true that in respect of the money spent on, for example, commissions and discharging professional fees, the SPVs received consideration. But with respect to the judge, that's not the point. What is the point is whether or not the effect of the transaction was or was not balance sheet neutral. And so in the present case, in the SIB rather, the monies were used to pay off pre-existing liabilities, so obviously and unquestionably balance sheet neutral. But in relation to this sort of transaction, by which investment monies are received, but some part of those monies are then used to pay off a liability which came about only as a result of the transaction, such as sales commissions, it's not balance sheet neutral.
Well, a genuine liability, because that may distinguish between your 12.5% and what at the moment looks very much as part of the whole fraud.
My lord, your lordship will have noticed in our supplemental skeleton argument, we did not refer to the development
No.
deferred
Well,
consideration.
that may be sensible. Yeah.
But in terms of the professional fees and the sale agents, these were independent, bona fide parties providing proper services. So the net effect was the SPV was worse off the tune of that immediately, necessarily, and automatically occurring expenditure. So it had suffered a loss. So with respect to the judge, while he's correct in itself that consideration was received, that's not the point. Because that liability was created by the transaction itself was not balance sheet neutral and a loss was suffered. And we say that in itself is sufficient with respect to merit permission to appeal being granted. My Lord, as for the second headline point, this is the compensation point.
Your second ground of appeal is outside the scope of duty.
Well, I was going to deal with that as my third point. I'm just going to deal with
Right.
that.
Okay. I was keeping you to the grounds of appeal in order. That's fine. You deal with it how you want. It's just then I know where to note these things. Yeah. Sorry,
Well,
you're now going back to the statutory compensation.
My Lord, yes. Perhaps I can develop that.
Yeah.
Your Lordship is, I suspect, familiar with section 26.
Well, I've had a chance to read it. Yes, thank you.
My Lord, yes. For what it's worth, it's in page 96 of the authorities bundle. And that provides that the investor in these circumstances is entitled to the return of the money and compensation. And has your Lordship seen section 28?
No, I didn't read that one specifically.
It's at page 103.
Hang on. Thank you.
Subsection 1, this section applies to an agreement which is unenforceable because of section 26. 2, the amount of compensation recoverable as a result of that section is the amount agreed by the parties or on the application by the party determined by the court. And the key one is subparagraph 7. If the person against whom the agreement is unenforceable elects not to perform the agreement, or as a result of this section recovers money paid or other property transferred by him under the agreement, he must repay any money and return any other property received by him under the agreement. So, my Lord, the regime is clear. The investor cannot have his or her cake and eat it. What the investor can get, 3 things. 1, their money back. 2, compensation. And the third thing, but he or she has to repay any benefits received.
Yeah, well, none of them received any benefits, did they?
My Lord, correct.
Yeah. And compensation is 28.2 then, amount agreed or determined by the court.
My Lord, yes. The source is section 26. 2B. The other party entitled to recover A and B compensation, and how it's determined is section 28.
Yeah, and the judge said, well, the person couldn't actually enforce the agreement, but 28.3 suggests that you can if it's just inequitable.
My Lord, yes. So effectively, an investor can elect to adopt or to affirm.
Yeah.
One could imagine a scheme which is partially successful. So one, under the scheme, the investor can adopt the scheme or can treat it as unenforceable. If the latter, unenforceable, they can get all their money back and compensation, but they have to give credit for or pay back the benefits they've received. Well,
Yep.
That's the regime. In this case, there were no benefits received. So that's straightforward. But the short point is that even leaving aside the immediately incurred, the commissions point, when £100,000 goes in, if one first of all imagines a different situation, imagine these had not been CIS, they had not been caught, then in that situation, the investor would have put his or her £100,000 in, and their investment is worth what it's worth. Here, because they are unauthorised, immediately the SPV is obliged to repay not only the £100,000 but some form of compensation. We accept there's been no adjudication on that under section 28 or otherwise. The liquidator hasn't adjudicated upon that, that's premature. But it's absolutely wrong, we say, to say that it's balance sheet neutral. So for this reason too, it's not balance sheet neutral. Now what I think we've suggested, if we were a punchy adjudication could suggest that the investor for his or her compensation could look to recover what they might have done with the money, which could be for similar returns. It could be interest. That's an assessment which needs to be made as to what each investor would have done with his or her money had it not been held up by these schemes. Now, that process has not been undertaken, as I explained, but we say it's therefore absolutely wrong to suggest it's balance sheet neutral. So we say this way too, it means we're not in Stanford territory. My Lord, the third headline point is in relation to the rest or the balance of the investment monies. And in relation to this, the judge referred to the Saddington case. At page 73 of the core bundle, at paragraph 112 to 114, could I invite the court to read those 3 paragraphs?
Is that the judgment?
My Lord, yes.
Right, yeah, I've just got it separately, yeah. So which paragraphs?
It's paragraphs 112 to 14.
Yeah, I've read them and reread them this morning, but I will read them now. You have 5 minutes left.
My Lord, if your Lordship has read them, perhaps I can...
Yeah, make your points.
The conclusion at 114
Yeah.
Is that it wasn't within the scope of duty. We say, with respect, that misses the point. First, to be absolutely plain, the claimants do not seek, and we've never sought, to blame Lupton Fawcett for the extent to which the investment monies were misappropriated by the Ponzi scheme. That cannot have been foreseeable. But that's likely to be actually a relatively small amount. We refer to the fraud judgment against Mr. Woodhouse. What we do say is this. Lupton Fawcett had prepared the paperwork. They therefore knew exactly how the scheme was supposed to work. And they knew therefore that the investment monies would be used in relation to the scheme in a way which over the short term would not give a pound for pound return. And the scheme, this was in the evidence, my Lord.
Yep.
The schemes were projected to make profit in, for example, years 6 or 7. And that's not an uncommon for the legitimate schemes, that in the short term there'll be a loss. So, my Lord, if the schemes had not been CIS, that risk would have been with the investors. So if at a particular moment early on, an investor had invested £100,000, and in the early years that investment was worth only £60,000, so be it. The investor was entitled to whatever the value was, because the scheme was worth less in the early years by its very nature. However,
how does the fact that the investor only pays 60,000 and is then initially given 100,000?
Well, that actually supports our case, because the liability is for the full investment of £100,000. But Lord, the short point is if the schemes weren't CIS, it wouldn't matter, because the investor, if the value of the investment is worth less, that's a risk on the investor, no liability on the SPV. Because, however, the schemes were CIS and unauthorised CIS, it meant that in that scenario, so where an investment of £100,000 was in the early years worth only, for example, £60,000, the SPV was liable to repay not £60,000 if it was compliant, but £100,000 plus compensation, and so it would be immediately worse off. Lord, this was something which was directly foreseeable by Lupton Fawcett. They had drafted the paperwork, and it was directly within the scope of their duty. They had been instructed to advise as to whether or not the schemes were CIS or not, and that's squarely pleaded. So, my lord, in terms of the Manchester Building Society case, in fact, if your lordship has the judgment, it's at paragraph 67.
Yep.
Um,
Where the judge dealt with it. Yeah.
My lord, yes. Paragraph 67, the judge refers to paragraph 6. It's points 2 and 5. In fact, the judge refers to paragraphs 2 and 5. When a claimant seeks damages from a defendant in the tort of negligence, a series of questions arise. 2, what are the risks of harm to the claimant against which the law imposes on the defendant? Duty to take care. The scope of duty question. And 5, is there a sufficient nexus between a particular element of the harm for which the claimant seeks damages and the subject matter of the defendant's duty of care as analysed at stage 2, the duty nexus question? And Lord, with respect, the judge below missed the point. This was precisely Lupton Fawcett's duty. They were aware of the nature of the scheme, i.e. it was not going to be a pound for pound return in the early years. That wouldn't matter if it was not CIS. But they were directly, expressly instructed to advise as to whether they weren't, and the commercial implications. And the implication of them not being authorised and the schemes being CIS was that they would become immediately liable for sums, thereby causing a loss. So, my lord, we say this is squarely within paragraphs 2 and 5 of Manchester Building Society.
Thank you very much. Right, and I think that's your time. Thank you very much indeed. Miss Manby.
My lord, I will respond to the appellant's case as put today and as in their original skeleton argument.
Yes, I mean, I think the reality is, and I'm well in mind that the respondent has justifiably claimed that they're moving sands, but at the moment we're still dealing with a case at an early stage. So if there are plausible claims, then subject to amendments and all the rest of it and costs and those issues, normally a court will allow it to go through, or at least consider there's a real prospect of success.
My lord, I would agree in the ordinary case, but this case is unusual in that we've had 6 iterations of the particulars of claim produced over the course of a year by the same legal team. And we made our strikeout application and had 2 or 3 more iterations of the particulars of claim after that.
Yeah.
And even then, and even now before you today, we have a case that is fluctuating. But the reason for my opening statement was really just to lay down a marker that I only received the supplemental skeleton argument from the appellants when I sat down this morning as you walked in. So I have not had a chance to consider.
Well, I got it yesterday. So, Miss Pickering, why wasn't it sent?
Lord, I'm not sure.
Well, take instructions. Yes, Miss Manby, carry on.
So I'll respond to what I've heard orally and I'll respond to their original skeleton, but I've not had a chance to consider the supplementary one.
Yeah. Well, not now, it'll come out of your 5 minutes. Just so that you can help. What concerns me is the judge was right, plainly right in the pound in, pound out. But what is said is that if you're looking at the fact that to get the pound in, you pay 12.5% to genuine independent people. Leave aside the 40%, which strikes me as the beginning of the Ponzi fraud, but I haven't enough information to make that determination. But leave aside that at the moment. That 12.5% is a liability the SPV had because they were engaged in a scheme that if they'd had proper legal advice, they wouldn't have touched.
Looking at it temporally first,
Yeah.
In the evidence produced by the claimants for the original hearing, they confirmed, and this was in the context of arguments we were running at the time about limitation, that the monies came in directly to the claimants at exactly the time that the liabilities, the contracts were entered into with the investors and the liabilities arose. So the full sum comes to the claimant SPVs at that point, less the developer's deferred deposit. And I'd just like to correct what was said about that deposit this morning. The developer is the individual claimant SPV. It's not some third party.
Yeah.
It is that claimant that is offering that scheme. And that's actually clear from paragraph 41 of the particulars of claim and the way that the claimants put their case there. It's effectively allowing the investor to defer paying a proportion of the investment, and in return, the SPV developer doesn't have to start paying the rental coupon for a number of years. So that's all about monies to the claimants themselves. It's not any third-party payment. But coming back to the other upfront, what have been called the upfront costs, so the commissions to sales agents, solicitors' fees, etc., building costs, those are only paid after the sums have come into the claimants themselves. So as a matter of timing, pound in, pound out, we have the money comes into the investor, from the investors to the claimant, they have it, and they have the corresponding liability. So we say the no loss point works there, and you don't need to look further. And that is because of the way that the claimants put their case. And their case is restricted to the Lupton Fawcett being responsible for advising on the CIS nature of the schemes. Lupton Fawcett aren't advising on how they operate in practice,
No,
or whether they're a Ponzi scheme.
Provisionally, I understand that. It's just this pound in, pound out. But in fact, for £100 in, you're only going to get 87.5 or whatever it is.
Well, the only amount that the claimants are not receiving is the sum that they themselves have deferred. And so they have, it's the sum that they have agreed not to obtain at that point, the developer's deferred deposit. Everything else comes into them. And this was paragraph 57 of Mr. Dunnell's first witness statement.
Yeah.
Everything else comes into them at that point.
And the sales agents?
Well, that comes out from the claimants thereafter. But we say that that's the no loss analysis has been satisfied at that point. What the
Well,
claimants...
can I just put it so as I understand it, so that you can show why it's wrong? If suppose this was a CIS, and suppose there was negligence for these purposes, which we have to assume at this stage, in not spotting that it was a CIS, what they wouldn't have done is got the £100 in, fine, and that's what they've got to pay back. But as well as the £100 in, they've also got to pay me, who's working in Chelmsford selling these schemes, 12.5%, and that is a loss. Which, if you'd have told me they couldn't have been involved with, they wouldn't have incurred. What's the answer to that?
Well, you've earned that sitting in Chelmsford selling the schemes,
Yeah.
and that's obviously so, especially for the sales agents, because they're only getting that money when they've sold them.
So far as I'm concerned, entirely agree with you, but they wouldn't have incurred that liability to me if you'd have told them this was a CIS.
But that's too simplistic a view. That's just applying the but-for test rather than looking more closely at the scope of our duty. So that's too simplistic analysis just to say no scheme, no sales agent fee. One needs to actually look more closely and see what it was that Lupton Fawcett were required to do.
Provisionally, again, I entirely agree with you, because that's all orthodox, and Manchester Building Society makes it clear. But if the scope of the duty is to say this is a CIS, so that I shouldn't be paying out monies to get monies into the CIS, then that might be considered to be within the scope of the duty. What's the answer to that?
Well, one only pays out those monies once they've come in the first place. It's not something that they pay in advance. But again, it's good consideration. They have sold these schemes, and someone has gone out, and whether it's a solicitor who's done work and drafting them, or whether it's a sales agent, they have earned that. It's a legitimate payment, and it's not said at any point by the claimants that those payments are illegitimate. They've had good consideration for them.
Thank you.
So we say that the no loss principle, which is now accepted, the claimants cannot get round it, and the way that they are seeking to distinguish the cases of Saddington and Stanford Investment Bank do not work. Our case is on all fours with those. It's also on all fours with the general principle of damages being compensatory and claimants being required to give credit for benefits. And that's a principle that's been restated by the Court of Appeal last week in Barrow, Fenn and Patel. Very clear that you have to give credit for the benefits that you've obtained. Saddington and Stanford are not properly distinguishable it's notable that the claimants have come to court today and the authorities they rely on are our authorities. They haven't come up with anything to go behind them. And the reasons that they've sought to distinguish them simply don't work.
Yeah, I mean, to be fair, Lord Justice Bean did direct them to try and distinguish them. So,
Yes.
so you can understand why the focus of the argument was on that basis.
No, quite, but they haven't managed to find any authority to distinguish them. They haven't found anything that suggests the distinctions that they seek to draw, for example, for pre-existing liabilities or for the fact that sums are not simply paid into a holding company. They have no authority to support that. So they're simply trying to limit the application of Saddington and Stamford, and where it's no part of those decisions that they are so limited. They are stating basic principles about claimants only being able to recover for losses that they've actually suffered and having to give credit for benefits that they've obtained. And to come back to the original point that was raised in their skeleton argument was that Saddington was distinguishable on the basis that the breach only provided the opportunity for the loss. Well, there's no principled reason to restrict the case, that principle, to only instances where it is only the opportunity for the loss. Indeed, cases where it is only the opportunity for the loss often fail for that very reason themselves. So there's no reason to, in principle, to be so restricted. We say, properly considered, the losses in this case, my client Lupton Fawcett could only be responsible for creating an opportunity for those. The poor business decision by Mr. Saddington with his use of the loan funds there is obviously comparable to what Mr. Woodhouse and MPD Limited here did with the funds from the claimants. And the claimants are wrong to present Lupton Fawcett's advice as integral to the losses suffered. The advice is on a discrete point as to whether or not the schemes are CISs, and the claimants actually had separate solicitors, who are the eighth defendant to this claim, Metis, acting for them on the transactions with investors, and doing that work for them. I've dealt with already the point about whether Saddington can be distinguishable on the basis that it doesn't include those upfront costs, and so our answer to that is, or firstly, that is not how the case is put in the particulars, all 6 iterations of them. Secondly, that the money comes in directly to the claimants before it's sent out in other directions. And thirdly, that these are normal commercial arrangements for which good consideration is obtained and they're arm's length transactions. And there's nothing pleaded about them being illegitimate. Fourthly, on the point that the schemes were only intended to be profitable in the medium to long term and that there were significant start-up costs, it's no issue for us whether there's a £1 in, £1 out return. The question is how it affects the balance sheet, and the defendant is not responsible for how the claimants spent the sums and whether their schemes were successful in either the short or the long term. And finally, coming to the £1 in, £2.25 argument, which was the focus of the claimant's case for some time, that the whole premise of their claim and the way that they've always pleaded it is that they became immediately liable to refund sums to the investors. And their primary head of damage is the sums paid to investors, which they pay by investors, which they must refund. And I must make a point of correction here of my learned friend, in that they do accept in Schedule 3 to their particulars of claim that there have been some returns to investors paid already. So those investors would have to give credit for those returns, and obviously the claimants would not be liable to pay the full amount invested where certain investors had already had returns. And as my learned friend did fairly point out, it is a choice for investors whether they claim a refund, if they go for the statutory rescission argument, or whether they ask for compensation. They cannot go for both, and that is clear from section 28(7) of FUSMA and from the Whiteley's case that we cite in our 3-page note. In terms of compensation, it's also important to see what we're looking at here. We're looking at compensation under section 26(2) for any loss sustained as a result of having parted with it. And that doesn't cover these losses now being claimed by the claimants. It's not expectation losses for the potential success of the scheme. So ultimately, this argument doesn't help the claimants circumvent the issues that they got monies from investors which directly corresponded to any sum they were immediately liable to repay. payments to third parties were for good consideration. And that Lupton Fawcett was not responsible for the commerciality of the deal from the claimant's perspective. Paragraph 33 of my learned friend's skeleton argument seeks to restrict.
That's the PTA skeleton argument.
Yes.
Yeah, thank you.
Seeks to restrict the application of Saddington and Stamford to cases where pre-existing liabilities are discharged. And it's important in this to note here, the claimants have made these concessions. They accept that the no-loss principle works where the claimants were holding, or where a recipient is holding the money and not doing anything with it, and where the monies are used to pay pre-existing liabilities. But there's no reason to so restrict the principle. There's no authority identified by the claimant to do so. And there's nothing in Stamford or SIB to suggest that this only works for pre-existing liabilities. Indeed, in Saddington, the mortgage advance is £175,000, of which £75,000 pays off the existing mortgage, and £100,000 is used to fund Mr. Saddington's business. Paying off the existing mortgage is not part of the claim. It's obviously understood by the claimants in that case that they've had good consideration there. They can't claim loss there. But the money to fund Mr. Saddington's business, that's not a pre-existing liability. That's a separate amount that he's utilised from the mortgage advance. But it's still found on that case that the claim fails for no loss on that particular head of loss.
Or outside the scope of duty, yeah.
Yes.
Being two sides of the same coin. Yeah.
But it's not a pre-existing liability. And in Stamford Bank, some of the sums which are paid to the certificate holders of the deposits, some of them go via a separate Stamford account with a different bank. And it's held that there's no loss suffered there when it's transferred to another. I mean, that's an obvious point, and the Court of Appeal notes that it's obvious. But again, that's not a pre-existing liability, and we still have the no loss analysis biting. And again, there is no principled reason to restrict the no loss analysis to discharging pre-existing liabilities, and it doesn't fit in with wider principles about damages being compensatory. Turning to scope of duty and the causal nexus point, which is the second ground of appeal. Yeah. We say that there's no loss by the claimants until the sums are lost and the claimants are unable to pay the investors. The reason that the claimants cannot pay the investors is because of the way that their schemes have operated and the dissipation that has happened of the funds that were paid to them and the fraud that is now part of the claimant's case. It's not because of the Section 26 liabilities. And it's because of this fraud, and it's not because of the CIS negligent advice. So it's not simply enough to say that but for the negligence of Lupton Fawcett, the schemes would not have been operated. One needs to go further and actually apply the Manchester Building Society analysis. And we say the judge did that entirely correctly. He cited the appropriate parts, and he looked at both stages 2 and 5 there to see whether the losses claimed were within the scope of duty, and was correct to conclude that they were not. That is the correct test to apply. It's settled law. It's not some test of proximity or foreseeability or fairness. It's to look at the purpose of the advice and to see whether the losses fit within that. Turning now to the third ground of appeal, the no compensation argument. The judge set out the easy air test. He clearly understood it. He was right to refuse to admit that argument, or at least he was entitled to refuse to admit that argument.
And what do you say about the fact that we're now told today there are coupons showing that these claims have been made?
Well, that is firstly too late.
Yeah.
Secondly, unevidenced. And thirdly, inconsistent with what we've been told before.
What have you been told before?
Well, in the grounds of appeal, they say it's premature to have admitted these proofs.
No, I don't think they've admitted them, but what they say is that they claims have been made. Whereas I think the judge said it was speculative to suggest that claims might be made.
The evidence that we were given on day 3 of the 3-day original hearing, given orally by my learned friend, was that there had been claims, but we've had no concrete proof of this. And it's now, most of these companies entered liquidation in 2019, so we were many years from when they've entered liquidation. There's been every opportunity to set this out. The focus has always been on the claims being for restitution of the invested sums.
Yeah.
And that will always be the largest claim. That's a 68 million pound claim, but 63 million when you give credit for the returns that were paid. As opposed to this compensation, the investors have elected for restitution. The compensation is limited. It's only to the loss of having been out of that money. We're not talking about some sizable claim for expectation damages. So any sensible investor will just be asking for their monies back.
Yeah.
And that is always how the claimants have presented their case until a pivot on the final day of the hearing before the judge, and no evidence there. And we say the judge was entirely entitled to reject such an argument, and that it's simply too late to have brought it up then, and it's even later still to be seeking to raise such arguments now, and to have no proper evidence before the court to support this. So unless I can assist any further.
No, that's very helpful, and you have been exactly on your time, Mr. Pickering.
Lord, I will be within my 5 minutes. First of all, in terms of skeleton argument, under Lord Justice Bean's direction, it was a direction that he did not direct the respondents to attend.
No, but he said they might attend. Did you find out whether they were?
We weren't aware until this morning that they were going to attend, and certainly I wasn't.
My lord, we've been asking for the bundle. We were also refused that. I think it was pretty obvious that we were going to be coming.
Right. Don't waste your 5 minutes on this, but I'm going to get to the bottom of this, and I'm going to make cost orders depending on it. Messing around doesn't help me at all. If there has been messing around, cost orders will follow. I'm not saying there has been. We'll find that out anyway. Right. Start your 5 minutes.
My Lord, I'm grateful. In terms of the two cases, Stanford and Saddington, we have never said they were wrong. We've accepted them. At the hearing below, we said they were good law. We've always said that they are not applicable to the facts of this case. For example, in Stanford, pre-existing liabilities, absolutely we accept that. As we've made plain, what we're seeking to rely on is not the discharge of pre-existing liabilities, it's the discharge of liabilities A, which were created specifically out of the transaction in question, and B, compensation which necessarily arises because of the operation of the scheme. Similarly with Saddington, that was clearly correct on those facts, but for the reasons we submitted, it's a million miles away, which is why we say this is a case which comes within the scope of duty. Lord, there is no case dealing with the precise points of compensation and immediately incurred expenses, which is perhaps one of the reasons why we are here today. My Lord, my learned friend made a point which with respect is bad in law, in terms of the genuine, bona fide, independent work done by the sales agents. They were not entitled to a commission unless and until the deal went through. It doesn't matter whether out of the £100,000 the money went to the went to the agents first, so the SPV received the net sum, or the full £100,000 hypothetically went to the SPV, because as soon as that company received the full £100,000, it became under a liability to pay and discharge the agent's fees. So the key point is not whether consideration was good consideration, but whether or not it impacted upon the balance sheet. And it did, because on the very making of the transaction, even if the full £100,000, for example, was received, that SPV became liable for example, 12.5%, and therefore it was not balance sheet neutral. Lord, in terms of compensation, my own friend has to underplay that. There hasn't been an adjudication for the reasons we've already discussed. We are talking about a claim of £55 million odd. If there is interest at, for example, 8%, and we are talking about a number of years. That's a hefty sum. If one looks at what the investors could have done with their money, again, on £55 million odd in total, it's a hefty sum. So again, my friend, with respect, didn't have any real answer to the compensation claim. There are compensation claims. And in terms of the paragraph where the judge below dealt with it, my Lord, can I refer you to that?
Paragraph.
It's paragraph 65.
Yep.
And I invite the court to look at that. And the final few lines, the judge said, I was shown no evidence that the investors had sought compensation, not the matter which is pleaded. Not an argument I therefore took into account. But what I'd actually said, one can see, is that investors would seek compensation. It's possible investors could seek compensation under the terms of the contractual arrangements. Now, my Lord, this is an early stage in the proceedings. There is no evidence, yes, and we accept there was no evidence, but it was a point which came up in argument. But we say it's obvious, given the regime under Section 26, that compensation will be due, and indeed, I can say on instructions, that compensation has been sought by the numerous investors.
And that, I think, is your 5 minutes. Have you anything else to say?
Well, my only final point was the point which your Lordship made. And if your Lordship feels there is something in this case and that the pleading isn't perfect, we do invite the court to enable the claimants to do so. In terms of Ms Manby's point that there's several drafts of the particulars of claim, with respect, that's slightly misleading. I think there have only been two substantive changes. Out of the various drafts, two related to changes in the figures, tweaking of the figures to do with limitation, and two related to new events. One, new material was obtained at the end of 2023, which was a subject of amendment, and four, there was also new material in relation to the Metis side of matters, which was new material. So there have been two substantive drafts as far as I'm aware. I'm grateful.
Thank you. Right, well, I'll give judgment. This is a hearing of an oral application by Afan Valley Ltd in administration and 42 other special purpose vehicle companies, who I will refer to collectively as Afan, acting by their joint liquidators, for permission to appeal against the judgment dated the 23rd of April 2024 of Mr. Justice Sheldon, who I refer to as the judge, and his order striking out and granting reverse summary judgment in relation to Afan's claims against Lupton Fawcett LLP, a firm of solicitors. The claim continues against other solicitors called Metis Law, who it seems were involved in the administration of the scheme and other advice. The oral hearing in the application for permission to appeal was ordered by Lord Justice Bean on the 30th of December 2024, who directed that Afan should focus on whether Saddington and Collies, a firm, 1999 Lloyd's Reports PN 140 Saddington and Stanford International Bank and HSBC 2021 1WLR 3507 as approved in the Supreme Court 2023 AC 761 Stanford International are genuinely distinguishable from the present case. He directed that Lupton Fawcett may, but were not required, to attend. I will unfortunately have to come back to that issue at the end of this hearing. I had the benefit of grounds of appeal running to some pages. It might be noted that the grounds of appeal contain submissions. This is in breach of Practice Direction 52C at paragraph 5.2, which provides that the reasons why the decision under appeal is wrong or unjust must not be included in the grounds of appeal. It is, however, possible to identify that there are three grounds of appeal, being no loss, outside the scope of duty, and compensation, which in this case seems to be compensation payable to the investors in the original scheme. I've also had the benefit of the judgment below and a skeleton argument in support of the appeal and a respondent's note pursuant to Practice Direction 52C, paragraph 19. There is a supplemental skeleton argument on behalf of Afan, which I received yesterday, but which Miss Manby, who appears on behalf of Lupton Fawcett, only received just before the hearing. I've got a bundle and a supplementary bundle, and I've had the benefit of oral submissions from Mr. Pickering, King's Counsel, on behalf of Afan, Miss Manby on behalf of Lupton Fawcett. I'm very grateful to them and their respective legal teams for the helpful written and oral submissions. By way of background, as this is an application for permission to appeal, I'll be short. In early 2016, a group was set up by Gavin Woodhouse. The business model of the group was to set up investment schemes in which investors, in return for their investment, would get an interest in a room within a hotel. In respect of each scheme, there was a special purpose vehicle company to receive the investment monies and operate the relevant schemes, and those form part of what I've referred to as AFAN. At all material times, the FCA was monitoring the group, and under the Financial Services Market Act 2000, sections 19 and 26 provide that no person may carry out a regulated activity unless they're authorised, and that is referred to as the general prohibition. If an agreement is made in breach of the general prohibition, money and other property paid or transferred is recoverable by the other party to the agreement. And in argument today, I was also taken to section 28 of FISMA, which shows how compensation is to be calculated, payable to those investors. Carrying out a collective investment scheme is a regulated activity. The effect of this, as Mr. Pickering put it, were that AFAN were not authorised to carry out regulated investment activities, was therefore vital to the group that none of its schemes fell within the definition of a CIS, because if they did, not only would the FCA take steps to close down the group, but section 26 would bite so that each SPV would be liable to return investment monies received to each investor and pay compensation to each investor for loss suffered. The group had instructed Lupton Fawcett and sought advice about whether the schemes were CIS. AFAN's case is that over the relevant period, Lupton Fawcett failed to advise AFAN that the schemes were CIS or that there was a real risk of the same, and that in those circumstances there was the risk of section 26 repayments due. In any event, over the following years, the group operated with various schemes being marketed, and they attracted investment, mostly from individuals, with a typical investment being quantified in the region of 100,000. In fact, it seems they put in 60,000 and were credited with the extra 40,000, according to the particulars of claim. But the total sums invested in the various schemes was over £68 million. Although, as was pointed out on behalf of Lupton Fawcett in the respondent's statement, limitation issues mean that the claim is for £55 million. In due course, the schemes failed. The SPVs went first into administration and then into liquidation with a net deficiency of over 68 million. In fact, it now appears that the whole scheme was a Ponzi scheme, and indeed judgment was later obtained against Mr. Woodhouse for some £2.3 million. Afan's case is that it is now clear that all the schemes were in fact CISs, and because none was authorised, and it follows that pursuant to section 26, all investors were entitled to return of their monies. In short, each SPV became liable to those investors. There have been various amendments of the particulars of claim, a point made by Miss Manby powerfully this morning, and indeed a point made on behalf by Lupton Fawcett is that the need for so many amendments proves the lack of any real or arguable claim. And indeed, this morning it appears that if the claim is to proceed, which would depend on any appeal, further amendments would be required. So far as is concerned, what happened below is that applications to amend were made, that was resisted, and at the same time Lupton Fawcett issued their application for reverse summary judgment and a strikeout. And so far as is material to the argument before me, the submissions were that first there was no loss because the monies owed to the investors was monies received from the investors, so it was balance sheet neutral, see Stanford Investment, and any loss, Stanford International, and any loss outside the scope of the duty of care because the reason for the loss was not because of the unauthorized nature of the scheme, but because the investment was in a Ponzi scheme. These were said to be both sides of the same coin. Material parts of the judgment below. In paragraph 101, the judge accepted the no-loss arguments made by Lupton Fawcett. He said the monies that are owed to the investors pursuant to section 26 must be offset by the investment monies that were received. Similarly for the monies received by way of secured loans. He also accepted that the losses that are alleged to have been suffered by the claimants were not attributable to Lupton Fawcett's alleged negligence. He said a distinction needed to be drawn between the receipt of monies, investment receipts and loan monies, and the use to which they were put. It is the use to which these monies were put that is the cause of the losses that the claimants have sustained, not the receipt of the investment or loan monies themselves. And at paragraph 112, he distinguished an argument which Mr. Pickering had made, which was that if the monies were simply held by the claimants or if they were used to discharge existing liabilities, that might be fine. But it didn't apply where the monies were paid to discharge future or outgoing or ongoing liabilities. And the judge said there's no difference between the two situations. And so far as the other losses were concerned, the judge did look at the compensation funds that were claimed, but he noted it hadn't been pleaded and that there was no evidence of the same. And for those reasons, he didn't allow the matter to go forward. The authorities, as far as Stamford International is concerned, the claimant was a bank in liquidation with debts of $5 billion as a result of being used as a Ponzi scheme. The bank had held bank accounts at HSBC. At some stage, HSBC had paid out £116 million to creditors, and the bank brought a claim alleging that by making those payments, HSBC had acted in breach of the coin care duty of care. And the judge refused to strike out. The Court of Appeal, affirmed by the Supreme Court, or the majority of the Supreme Court, allowed the appeal and struck out that claim. And the agreed basis for that was because the monies that had been paid out by HSBC had reduced the liabilities that were held by the bank. So far as Saddington is concerned, Mr. and Mrs. Saddington owned a house. Mr. Saddington sought a loan to be charged on the house. The valuer was instructed to value the property and he overvalued it. Mortgage was executed for £175,000, relying on that overvalue. And of that, £75,000 was used to discharge the existing mortgage, with the remaining £100,000 being used by Mr. Saddington for his business. In due course, that failed, and Mrs. Saddington sued the valuer, alleging that it had overvalued the property. In terms of loss, she claimed that she'd been subject to a liability for £100,000, which might mature into a financial loss. The Court of Appeal held that the loss resulted from the use to which the monies were put, which couldn't be attributed to the valuers. Might also be noted that this was at the time where the jurisprudence of no loss and no transactions was floating around the courts before it had been put right by the Manchester Building Society case in the Supreme Court. Mr. Pickering has attempted to distinguish those cases on a number of different bases. The latest basis in the supplemental skeleton argument on behalf of the appellant claimants is effectively making a series of submissions in relation to the 12.5% that is due to the sales agents on the monies that were invested in the schemes, which he said did form part of the scope of the duty of care because Lupton Fawcett had been asked to advise on the paperwork in relation to the schemes. In these circumstances, the test for me is whether there are grounds of appeal with a real prospect of success or any other compelling reason to hear the claim. And so far as a strikeout is concerned, the judge was applying the tests whether there was any arguable claim or whether there was a claim on the reverse summary judgment with a realistic prospect of success. So far as the first and second grounds of appeal are concerned about whether there was a loss or any loss that had been suffered was outside the scope of the duty of the care, the point that is now put is that if one looks at the scheme as it operated, and for these purposes arguably sanctioned by Lupton Fawcett, £100,000 came in, but £12,500 was due to the sale agent for that. And although 100,000 comes in and 100,000 goes out, makes it balance sheet neutral, the 12.5% to the sales agent is in fact separately money that was didn't make this transaction balance sheet neutral, and was a loss that was incurred by the Afan because they had not been advised that the scheme wouldn't work. Otherwise, they wouldn't have incurred the £12,500. So far as the answer to that is concerned, Miss Manby, who, to be fair, had not been given the supplemental skeleton argument before this hearing, and I'll come back to deal with that afterwards, made a number of points in relation to that. It was submitted that this was paid after the monies had been received in. It was too simplistic a view of the scope of the duties. The money was only paid out and there was good consideration, and damages were compensatory, and this was not a compensation. Miss Manby also pointed out that Mr. Pickering had not sought to rely on any authority other than Stamford International and Saddington, which were in fact Lupton Fawcett's authorities below, and that in those circumstances this was a speculative claim, and that was no basis on which it could succeed. It's sufficient at this stage for these purposes to say that it does seem to me that there is a claim with a sufficient, arguably sufficient prospect of success that merits consideration by the Court of Appeal about whether or not the liabilities going out of the 100,000, i.e. the 12.5% to the sales agent, which was part of the original scheme on which Lupton Fawcett advised, did mean that this was not balance sheet neutral within the meaning of Stamford International, and was within the scope of the duty of care for the purposes of Saddington, because this was part of the scheme on which Lupton Fawcett were advising. For those short reasons, it seems to me appropriate to grant permission to appeal. That covers grounds 1 and 2. In those circumstances, I will leave in ground 3, but there is, in my judgment, very considerable force in what the judge said about this not being pleaded and not being evidenced. So far as the pleadings are concerned, I should also make the point that at the moment, the way in which the 12.5% is put is not at all clear. Mr. Pickering, when taxed on it, said, oh, well, we claimed the whole amount, as if that might explain this particular way of meeting the claim, or putting the claim, and referred to the prayer, which provisionally seemed to me insufficient ways of making it fairly clear to the respondent that this is the basis on which the well-known authorities of Stamford Investment and Saddington could be distinguished. But those are matters which will be for the appeal and not for me. So for those short reasons, I will grant permission to appeal. It is perfectly apparent from the scenes we've had this morning in relation to what has been sent to each other that this appeal is going to need some case management, which I will now deal with. Mr. Pickering, time estimate.
My lord, for the appeal, my professional view is will be 2 days, my lord.
Seems pretty smallish.
But no more than that.
Ms. Manby,
We were thinking more just a day that it could be dealt with.
day and a half.
Grateful.
In terms of Mr. Pickering, it's entirely up to you whether you decide to actually put in particulars of claim which particularise your loss. As I said, provisionally, it seems to me they certainly don't do this, and it may well be the Court of Appeal says, well, you're too late. But
Well, could we
I'm
ask
not
for-
going to make any directions in relation to that. But you will have to produce a bundle. At the moment, we've got a core bundle and a supplementary bundle, which are prepared for these purposes. Do you have any dates by which you want to produce any skeleton argument to which you may, I suppose, attach your latest particulars of claim?
My lord, given that I suspect the appeal wouldn't be for some time, could we ask for 6 weeks from today?
For a day and a half, Miss Manby, does that cause you any difficulties?
No.
No. Okay. So what is that? 4 p.m. on.
I can work that out.
I think it's the 12th of March.
Thank you. So by 4 p.m. on the 12th of March, 2025, core bundle with all that's required, the supplementary bundle, and you are going to then put a skeleton argument for the appeal, are you?
My lord, yes.
Yeah. And if you annex to that what any amended particulars of claim, fine. No doubt Miss Manby can say that you shouldn't have that opportunity, but those are matters that we'll deal with.
My lord, I did say 6 weeks. Because of my own diary, I hadn't appreciated the 12th of March. Could I invite the court to make it a further 14 days after that? Only because I have some heavy professional commitments leading up until early March.
Right. What else will need to be done? There's a respondent skeleton, and it's not going to get into the list ready until October. So,
That's my estimate. We're talking about.
Miss
that
Manby?
within its term.
We don't have an issue with that.
right. Okay. Well, I mean, I'm not here to make anyone's life more difficult, but I am here to try and ensure that we get everything dealt with properly. Okay. Well, then, shall I say 4 p.m. on the 26th?
My lord, I'm grateful for that.
And then respondent's skeleton argument.
Yes, I'd also ask for a generous period for us to prepare that afterwards, so 6 weeks.
Which would take you to.
The 7th of May.
Right. Can I also direct that the contents of the core bundle and supplementary bundle are to be agreed, if possible, by liaison between the parties, so that we don't then end up with bundles and supplementary bundles, further supplementary bundles. Then 4 p.m. 7th of May for the respondent skeleton, and then 14th of May for the agreed bundle of authorities. Is that all right with both of you?
My lord, yes.
Right. Okay. Now, are there any other directions that are required for the hearing of this appeal?
Lord, not from our side.
No, my lord.
Right. Thank you. Now, what about this? The application for permission to appeal was made. The judge directed there be an oral hearing. He directed that Lupton Fawcett may, but were not required to appear. I appreciate that was the 30th of May, but we are now well into legal term because we are on the 29th of January. And what you said to me when we were just dealing with that you'd asked for the bundle. When had that been asked for?
We asked for part of the bundle back in, I think it was June. We asked for the chronology, which is something we'd not seen before. And we were told that we wouldn't be given anything until after permission had been granted.
Right.
We were then served with the index last week, and we asked again for the bundle. And we were told no, because they weren't required to give it to us. And we then said, can we at least have the chronology? And we were told no.
Right. And why was that?
My lord, perhaps I can take details.
Of course you can, because I'm going to give a short judgment on this. It's not, very helpful if parties don't cooperate. Both parties have a duty under the overriding objective to cooperate with the court and each other. because otherwise we waste time. I've got to get back to something else, but I'm not going to leave you before I've sorted this bit out.
Well, look, I will take instruction if I may. But the short point is, my understanding is we weren't aware. We were aware, of course, of Lord Justice Bean's direction, which my understanding is the usual direction in accordance with CPR 52.5. In other words, that the party may voluntarily attend, but is not required to do.
Yeah.
And it was merely restating that. And what we can look at, if need be, the general position is that the respondent will not get its costs in that situation.
Yeah.
By contrast, if the court directs an attendance where the respondent has to attend. We were in the former territory, and it wasn't. I personally wasn't aware that there was going to be any representation today. I'm not sure what the position is as to why the skeleton argument wasn't served. I suspect it's right to say they weren't actually entitled to it. I'm not sure if there was a request.
Well, they wouldn't have known that you were putting in a supplementary skeleton.
But my lord, I appreciate that. I'm not aware. I will check. I don't think we were expressly told there would be attendance today. If we had been told, that would have made a difference. Perhaps I can double check that.
Thank you. Ms. Manby, did your instructing solicitors say that that you were attending today?
No, we didn't say we were attending. It was obvious from the fact we were asking for the bundle. And the correspondence. From the court to us.
Right. Why didn't you say in terms we're coming along?
The court had copied us into various emails about our attendance, so we had given the court details that we were coming.
I appreciate that, but neither had spoken to each other. I mean, at the end of the day, that's the whole point of the CPR saying overriding objective is that parties cooperate with each other rather than treat each other as enemies for these purposes and deal with it. And then we don't waste time with no one having the proper bundles. I'm slightly inclined to think it's a bit of a plague on both your houses and just leave costs in the case. But at the moment, I'm deeply unimpressed that a request for a bundle was meant no. And secondly, that the skeleton argument wasn't at least proffered. On the other hand, writing correspondence without actually saying, by the way, we're coming along and appearing as a sort of rabbit out of the hat, as it were, is hardly likely to induce cooperation on the other side.
No, we were never asked if we were coming, though. We didn't hold that back.
No, but I mean, was it impossible to say, by the way, we're attending?
Perhaps we could have been clearer. We would say that the request for the bundle made it clear that we were going to be here.
Right, thank you very much. Both sit down. I'm deeply unimpressed by the performance on both sides. There seems to have been a fundamental lack of cooperation between the solicitors. On one side, when a solicitor's firm asks for a bundle, then plainly there's no duty to provide it in circumstances where you don't know that the other side are turning up. But you might have thought that that would have induced the question, are you turning up? Will you pay our photocopying costs? And as far as the other side asking for the bundle, you might say, as a matter of courtesy, by the way, we're turning up to resist this. It strikes me as examples of litigation that do no one any credit at all. In those circumstances, what I'm going to do is leave the costs of the permission hearing in the appeal, and whoever wins will no doubt get them. But I very much hope that going forward, people will start talking to each other because it will reduce the costs. Anyway, that said, I still remain very grateful for all the hard work that has gone into the hearing today.